Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Get ready for the editorial dictation. The Supreme Court of India's verdict upholding the abrogation of Jammu and Kashmir's special status under Article 370 of the Constitution represents not merely judicial difference but a retreat from the court's known positions on federalism, democratic norms, and the sanctity of legal processes. It is undoubtedly a political boost to the ruling BJP and an endorsement of its audacious move in August 2019 to strip Kashmir of its special status and bring it on a par with other states. However, it is also a verdict that legitimizes the subversion of federal principles, fails to appreciate historical context, and undermines constitutional procedure. The most potent attack on federal principles is the court's unconscionable conclusion that Parliament, while a state is under President's rule, can do any act, legislative or otherwise, and even one with irreversible consequences, on behalf of the state legislature. This alarming interpretation comes close to undermining a basic feature of the Constitution as enunciated by the Court itself, and may have grave implications for the rights of states, permitting a range of hostile and irrevocable actions in the absence of an elected body. The government and its supporters have much to cheer about, as the Constitution Bench has endorsed its stand and rejected strong arguments from the petitioners, especially the point that the government had acted in a malified manner by imposing President's rule preparatory to the intended abrogation of special status without the need to involve any elected representative from Jammu and Kashmir. The government had adopted a complicated process to give effect to the ruling BJP's long cherished ambition of removing the state's special status. It had gone on to divide and downgrade it into two union territories, UT. It began with a constitutional order on August 5, 2019, applying the whole of the constitution to Jammu and Kashmir and changing some definitions so that the state's legislative assembly could recommend the abrogation instead of its now dissolved Constituent Assembly as originally envisaged in Article 373. Ultimately, the court ruled that parts of the August 5 order were unconstitutional, as they in effect amounted to amending Article 370 itself, which was impermissible, but in a peculiar twist. It held the consequential notification on August 6, declaring Article 370 as valid, and that the President was empowered to do so even without the legal underpinnings of the previous day's notification that sought the bolster the validity of the action. The president could remove the state's special status without any recommendation. The court has reasoned that the Constitution of India has been applied incrementally from time to time, even after the Constituent Assembly was dissolved in 1957, and that the removal of special status is nothing but the culmination of the process of its integration. Even if this line of argument is seen as unobjectionable, the idea that in the absence the Constituent Assembly and in view of the subordination of Jammu and Kashmir to the sovereignty of India, there is no fetter on the government's intention to hollow out its residual autonomy is opposed to all canons of federalism and democracy. There is no doubt that Jammu and Kashmir is not vested with any sovereignty.